India Confederation of the Blind. Training workshop on the rights of persons with disabilities with particular emphasis on the visually impaired for AICB affiliates in South India. Sponsored by Danish Association of the Blind.
Good afternoon, everyone, and welcome back after lunch. We are very happy to have with us as an eminent lawyer, a wonderful person, a great friend of AICB, and a strong activist of the disability sector. Mr. Rajan, I welcome you here. Rajan and I and AICB share a very long association of, I would say, nearly 15 years now. I remember early days in the late 2007, 2008, 9, when we started working together on the railways case and other cases of AICB. This is where Rajan and I came close, and he worked with us, helping us in AICB. He has gone many miles after that. He's worked with a number of disability rights organizations, has been a part of a number of impact cases on disability in judgments which have been pronounced by the Honorable Supreme Court of India. He is a key player in the reservation in promotion case also, which is still going on in some way or other. There have been some judgments, but there are still clarifications and other applications by the government. He has his own foundation now, but always willing to help and great support to us whenever we needed him, whenever we need him. He's the best person perhaps to talk to us about important judgments regarding disability law and what has been the impact of this judgment on disability sector, in what way over a long period of something like 27 years, 26, 27 years. I'm saying 26, 27 years because PWD Act was in force since 1996. So a lot of judgments came during that. More recently, a lot of judgments have been there, particularly by the Supreme Court. I know that the area is very vast, Rajan. It's very difficult to cover. So focus on the more recent, perhaps, and going from there, some of the earlier ones, which were impact judgments, and how then we can make use of this judgment in our advocacy would be some of our expectations as we hear from you today. Your flow would be in around 2:45, so maybe in 2:35 or 2:40, we could have the presentation, and then another few minutes for question answers. The floor is yours, Rajan. Thank you very much for joining once again.
Yeah, thanks, Anil. Thank you so much for that very kind introduction. Thank you so much. Am I audible?
Yes.
Okay, wonderful. So good afternoon to everybody. It is a great pleasure to be here with all of you. And it's great to see the interest in this subject of realizing affirmative action and rights for persons with disabilities through disability law. So the topic given to me today is realization of rights through judicial activism, some important judgments. And I'd like to make a slight modification to that. Rather than say judicial activism, I would say the activism of people from the disability community. Because ultimately, and over the past, especially the past 10 years, there have been some very, very good judgments from the high courts, even the employment tribunals, and certainly the Supreme Court. I would say more than judicial activism, this has really been the activism and the efforts and the sincerity of those from the disability community that has resulted in this in these judgments coming. Let me just begin by quoting to you what the Supreme Court has said in a 2016 judgment in the case of Jija Ghosh. Some of you may know Jija Ghosh is a person with disability, a disability being cerebral palsy. And she has been very active in the disability sector insofar as advocacy and affirmative action. She's been standing up as a shining example of what one can achieve if one stands up for one's rights. There was a 2016 judgment of the Supreme Court, which I'll get to in more detail, but let me just read the concluding paragraph of that judgment. In Jija Ghosh, the case of Jija Ghosh versus Union of India, we would like to conclude this judgment by observing that to most disabled persons, the society they live in is a closed door which has been locked and the key to which has been thrown away by others. Important, thrown away by others. Helen Keller has described this phenomenon in the following words. Some people see a closed door and turn away. Others see a closed door, try the knob, and if it doesn't open, try the knob, and if it doesn't open, they turn away. Still others see a closed door, try the knob, and if it doesn't work, they find a key. And if the key doesn't fit, then they turn away. A rare few see a closed door, try the knob. If it doesn't open and the key they find does not fit, they make one. So this is the Supreme Court in a 2016 judgment appreciating the efforts of those rare people with disabilities that are not content to just stand by and watch nothing being done insofar as the implementation of all these wonderful laws that we have in India. The laws come from international sources, the UNCRPD, etc. And unless there is activism on the part of persons with disabilities, nothing happens. The other aspect is that when we talk about affirmative action, what is affirmative action? It is basically all those positive measures, positive discrimination that is required to bring people with disabilities on a level playing field. And why is it that we only need to go to the courts to get some implementation of affirmative action as required by law? Clearly because disabled persons have got no political constituency. All other disadvantaged groups we know, SC, ST, OBC, etc., have a very strong political constituency because they are geographically concentrated. Disabled persons are dispersed in the entire population. And so, therefore, to realize rights and to implement affirmative action, the only option is to go to the courts. And we've been fortunate over the past 10 years to have some good judgments from the High Court, the Supreme Court as well. And so I would like to take about the next half an hour or so, highlighting some of those important judgments. And what I will do is to organize my talk in the four main areas, which is employment-related judgments, then education-related judgments, then judgments related to accessibility in the public space, etc. And then finally, a more recent concept, which has been introduced in the new law, the 2016 Disability Act, which is now getting attention, which is the concept of reasonable accommodation, which many of you may have heard and engaged with. So these are the four areas. Now, just for the sake of completeness, I want to begin with a judgment, which is a little bit older, but still has a very, very pronounced impact on the disability law today. And this is a judgment of Ravi Prakash Gupta versus Union of India, going back to 2010. And what I will do is I'll briefly mention what the judgment is, what the judgment covers. And then for those who are interested, I will give the judgment citation. So once you put that citation into Google, you can get the judgment right away. Google makes things very easy these days. So Ravi Prakash Gupta was one of the visual impaired community and a very intrepid person. In 2006, he sat for the IAS exam, and in the visually impaired merit list, he stood 6th. And the IAS did not give him any appointment because they said that we only have one vacancy in that particular year, 2006, for the visually impaired category. The reason being that the identification of the job of IAS for visually impaired people only happened in 2006, but not before. Now, Ravi Prakash Gupta, whom I actually happen to know because he came to consult with me, although ultimately he argued the matter himself in the Supreme Court in person. And it's quite impressive that he did that and managed to win this case. His argument was that the Disability Act came into force in 1996 to begin with. So in those 10 years that the government didn't bother to identify IAS posts for visually impaired, what about the reservation obligation then? That was a backlog. And the Supreme Court said, absolutely, you're right. There may be one vacancy in the current year, but since 2006, there are 8 more vacancies as backlog vacancies. And so if Ravi Prakash Gupta stands 6th in the merit list, taking into account the backlog vacancies, he deserves to be appointed. And this is what the court said. while it cannot be denied that unless posts are identified for the purposes of Section 33 of the aforesaid Act, no appointments from the reserved categories contained therein can be made. And to such an extent, the provisions of Section 33 are dependent on Section 32 of the Act. But the extent of such dependence would be for the purpose of making appointments and not for the purpose of making reservations. In other words, reservation under Section 33 of the Act is not dependent on identification. So what the court is saying is that if you fail to identify posts because of your own administrative laxity, you cannot claim that the reservation itself has been defeated for that period. And this was a landmark judgment which essentially established the idea of backlog. Although there were government OMs that talked about backlog, but this is a Supreme Court judgment that said that even backlog vacancies will be taken into account for current recruitment. The other case which is relevant, as Anil recently just now mentioned, AICB, and we must appreciate AICB for all the efforts they have taken in legal advocacy. Very sincere efforts. And not only myself, but other lawyers have really taken up AICB cases in the courts, High Court, Supreme Court, etc. And we must appreciate that. This was a 2012 judgment of AICB versus the Ministry of Railways. And this was a case where since the 1996 Act came into force, and for a period of 10 plus years, the railways had been undertaking mass recruitment drives. And many people might know that the railways are the largest public sector employer in the country. As far as I know, approximately 10 lakh people are employed in the railways. So they have been conducting large-scale special recruitment drives, but not having any reservation at all for persons with disabilities, including in Group C and D and A, etc. So AICB filed a writ petition in the Delhi High Court challenging this, and taking into account the judgment in Ravi Prakash Gupta that even backlog has to be filled. The court in 2009 asked the railways to do a complete calculation of the entire backlog in Group A, B, C, D for persons with disabilities, and came to the conclusion that there was a backlog of around 4,200 vacancies. And then directed the railways to, in one go, in a special recruitment drive, fill all those vacancies. It was really a very, very remarkable order of the court. 4,200 vacancies in Group A, B, C, D. It's very interesting that when the railways was faced with this obligation, they said to the court that we are an operations and safety-based organization. And therefore, we do not think, especially in the operational posts, that persons with disabilities can be hired with regard to safety. See what the court said in response to that plea of the railways. The court said, we must take note of the rapid advancement in medical science and technology, which is progressively ameliorating the hardship faced by the person suffering from various kinds of disabilities. With the advancement in technology and advent of supports, as may be provided through supported employment, the notion of equating disability with inability to work is erroneous and outmoded. There should be a presumption of ability that a person can achieve employment and other rehabilitation goals regardless of the severity of his or her disability if appropriate services and supports are made available. And having found so, the court proceeded to direct a special recruitment drive for 4,200 vacancies, including 66 vacancies in the prestigious Group A, Indian Railway Account Service and Indian Railway Personnel Service, filled through the civil service examination. 66 vacancies. And we all saw that after the 2012 judgment, there were a series of advertisements by the railways in their attempt to fill these vacancies. And for those who would like to look up the judgment, it is in the Delhi High Court, writ petition civil number 23132 of 2005. And the judgment was pronounced on 7th March 2012. Just to go back a second, the Ravi Prakash Gupta judgment was pronounced on 7 July 2010, and the citation is 2010 7 SCC 626. Now, moving on to the more recent issue on employment. So the cases I mentioned and many other cases filed by many other organizations has resulted in a fairly widespread and fair recognition that in the course of direct recruitment, reservation has to be provided, not only the current reservation, but also the backlog. Now the question is, what about after recruitment and while in the service, while in the job? What about promotion? So one has seen that when it comes to the other disadvantaged groups, there has been a widespread demand for reservation and promotion. The groups such as SC, ST, OBC, etc. Recently, the Supreme Court has said, insofar as reservation and promotion for the other disadvantaged groups, SC, ST, OBC, it should be based on inadequacy of representation in the cadre. The Supreme Court has said that for SC, ST, OBC, if you want to provide reservation and promotion, you must first establish by collecting data that there is inadequacy of representation in the cadre. Now, as far as disabled persons are concerned, we know a priori that there is definitely inadequacy of representation. There's no question about that. Especially the higher you go in Group A, etc., the less you will find the prevalence of persons with disabilities. And so, because of the inherent biases in the promotion process, especially when the promotion is by competitive selection, it is probably more required that persons with disabilities be given the advantage of reservation at the promotion stage in employment, even compared to the other disadvantaged groups. So the judgment that was most relevant in on this issue, the judgment of Rajiv Kumar Gupta versus Union of India. This is a judgment pronounced on 30 June 2016. And the citation is 2016 13 SCC 153 on the question of reservation and promotion for persons with disabilities. So here, Rajiv Kumar Gupta was a orthopedically disabled employee of Prasar Bharati Doordarshan. And he and 7 other of his disabled colleagues who were working in various engineering posts in Prasar Bharati Doordarshan sought the benefit of reservation and promotion because all the successive posts in the engineering cadre were identified for persons with orthopedic disabilities. And so they claimed the benefit of 3% reservation, as was in those days, in promotion as well. Now, a writ petition was filed directly in the Supreme Court. And the reasoning given for this was that Prasar Bharati, like Railways, is an all-India organization, and the judgment would have an all-India effect. The Supreme Court accepted the writ petition. Now, the Prasar Bharati relied on a 2005 government OM, which many of us may be familiar with, which did a very funny thing. It said that reservation and promotion is allowed for persons with disabilities, but only in Group C and D, not in A and B. And there was no particular reasoning for this, because the Act, the Disability Act, whether the earlier Act or the new Act, is uniform and does not distinguish between the different cadres and the different posts. So ultimately, the Supreme Court accepted the petitioner's argument that whenever a post is identified, irrespective of the mode of recruitment, whether it is by promotion or by direct recruitment, there must be reservation. And the court said, a combined reading of sections 32 and 33 of the 1995 Act explicates a fine and designed balance between requirements of administration and the imperative to provide greater opportunities to PWD. Therefore, as detailed in the first part of our analysis, the identification exercise under section 32 is crucial. Once a post is identified, it means that a PWD is fully capable of discharging the functions associated with the identified post. Once found to be so capable, reservation under section 33 to an extent of not less than 3% must follow. Once the post is identified, it must be reserved for PWD irrespective of the mode of recruitment, that is either by direct recruitment or by promotion, adopted by the state for filling up the said post. And in coming to this finding, the Supreme Court set aside set aside the provision in the 2005 OM that provided reservation and promotion only to C and D, but not to A and B, and said it must be provided in all groups and all grades, so long as the post is identified. So this was a 2016 judgment, and we were all quite happy and relieved that we got this judgment from the Supreme Court. But there was a twist. There was a twist. Because in December, only 6 months later, Mr.Rajan from the Karnataka State Civil Services, he demanded that he should be given the benefit of reservation and promotion to the IAS. There is a channel from the State Civil Services to the IAS. And the DOPT denied that. He went to the High Court, Karnataka High Court, and the Karnataka High Court rejected his claim. The reason for that was that when the Karnataka High Court came to his judgment, the Rajiv Kumar Gupta judgment had not yet been passed, unfortunately. Now, based on being rejected at the Karnataka High Court level, Mr.Rajan went to the Supreme Court. And in June of 2016, although just 6 months earlier, the Supreme Court had said very clearly that whenever the post is identified, there must be reservation and promotion. Still, the government was very keen to defeat this. They sent their top lawyer, the Solicitor General, to the Supreme Court to argue that Indira Sahni 1990 judgment did not permit reservation and promotion constitutionally. That was overridden by the government by an amendment to the Constitution only for SC/ST, and therefore, according to Indira Sahni, there is no reservation and promotion available to persons with disabilities constitutionally. There is a constitutional prohibition in the Indira Sahni case, was what the top lawyer of the government said in December, despite the fact that this very issue had been dealt with in Rajiv Kumar Gupta. In Rajiv Kumar Gupta, the Supreme Court, Justice Chelameshwar, who authored the judgment, very clearly said that the prohibition in Indira Sahni is to do with the SC/ST category, but not with the disability category. So that argument does not apply here. However, in December of 2016, a different bench, a coordinate bench, a two-judge bench of the Supreme Court, wanted to indulge the government's argument again. And so they referred the whole question of reservation and promotion to a larger bench, a three-judge bench, for re-looking at this issue. And we were all very perturbed about that. Now, for the succeeding 3 years, the government taking advantage of the pendency of this petition of Mr.Rajan in the Supreme Court, even though Rajiv Kumar Gupta, the 2016 judgment, ruled the field, but the DOPT did not allow a single reservation and promotion. Whenever there were claims made by persons with disabilities in the various departments and the public sector units, that claim was referred to the DOPT, and the DOPT's stock answer was, this matter is pending adjudication in the Supreme Court. Although the law does not say that because the matter is pending in the Supreme Court, that a previous judgment of the same court can be ignored. So long as a judgment of the Supreme Court is not overruled by a subsequent judgment, it is still in force. Be that as it may, ultimately in June of 2020, almost 3.5 years later, a larger bench, a three-judge bench of the Supreme Court, took a look at this issue once again in the case of Mr.Rajan. And much to our relief and much to our joy, a three-judge bench led by Justice Rohinton Nariman of the Supreme Court reaffirmed Rajiv Kumar Gupta and said as follows. After hearing learned counsel appearing on behalf of all the parties, including the learned additional Solicitor General, we are of the view that the judgment of this court, that is the judgment of this court in Rajiv Kumar Gupta, cannot be faulted when it stated that Indira Sahni dealt with a different problem and therefore cannot be allowed. We may also note that review petitions were filed and have since been dismissed against both the 2013 and 2016 judgments. Consequently, this reference stands answered by stating that the 2013 judgment, that is the National Federation of Blind Judgment, and the judgment in Rajiv Kumar Gupta will bind the union and state governments and must be strictly followed. So this is what the 2020 judgment in Mr.Rajan affirms the Rajiv Kumar Gupta judgment, and now making it the law of the land that reservation promotion must be given to persons with disabilities in employment. Now, the latest position on that despite this judgment of 14 Jan 2020, a judgment of a larger bench, affirming Rajiv Kumar Gupta, taking advantage of the lockdown, etc., and very, very keen to somehow delay or deny this particular reservation and promotion, the government in October of 2020, right in the middle of the lockdown, filed an application for clarification. An application for clarification of a judgment that was very, very clear. So this is what the government does when they wish to somehow delay and deny. They filed an application for clarification in a judgment that was very clear. One of their requests for clarification was whether, again, reservation and promotion applies in Group A. They said that, well, we don't give SC/ST persons reservation within Group A. Whereas Rajiv Kumar Gupta was very, very clear and in fact specifically set aside the 2005 OM, which did not give reservation in Group A. And Rajiv Kumar Gupta said when the post is identified, whether it is in Group A or wherever it is, reservation and promotion must follow. This application for clarification was in September of this past year, 2021, turned down by another 3-judge bench of the Supreme Court. And the court said that there is no need for any clarification. And the court has also issued a direction to the government that insofar as the new act is concerned, the 2016 Act, they must issue comprehensive instructions regarding reservation and promotion to all the departments and cadres. And that is currently being awaited from the government. Now, let me move on. So this was employment. Let me move on to education. And I'll just pick out 3 judgments. I'm going to focus on higher education, although there are a lot of very, very good cases, especially from the Delhi High Court in school education as well. And there are AICB cases also. I recall, Anil, our very first case was getting textbooks in Delhi schools being printed in Braille, which was not being done earlier. It was a very, very old case, yes, that we did together. But let's look at the higher education issue. So what are the issues in higher education, right? So we have a 5% reservation, as we all know, in the Disability Act, both in the earlier act as well as the latest act, 5% reservation. Now, what we have seen happen very often, and especially in the professional colleges, medical colleges and engineering colleges, is that there is an entrance exam, a very tough entrance exam, okay? And what is being done is that the minimum qualifying marks in the entrance exam are not being relaxed for persons with disabilities, even though the 5% vacancies for them in the seats remain unfilled. This has happened fairly frequently in the past. So the same minimum qualifying marks as applicable to the general category has been made applicable to the person with disabilities, and only the SC, ST, etc., OBC get a relaxation in the minimum qualifying marks in the entrance test. So there was a very good case of the Delhi High Court. This is a 2012 judgment, Anmol Bhandari versus Delhi Technological University, the erstwhile Delhi College of Engineering, which is now Delhi Technological University. In the engineering courses, they were having an entrance test with 55% relaxation, 55% minimum qualifying marks for the general category, relaxed to 50% for the SC, ST, OBC. Anmol Bhandari sat for the exam and he's a person with disability, and he got 52%. So he was denied admission because he was not meeting the general standard of 55%. All those seats in the engineering college remained available, remained vacant. And so he went to the High Court, and the High Court, in a very comprehensive judgment, in this case, in a comprehensive judgment, taking a look at a report of the World Bank on the condition of persons with disabilities vis-a-vis the other disadvantaged groups in India, that is the SC, ST, OBC, etc. The High Court noted that the World Bank found that disabled persons in terms of their socio-economic parameters are even more at a disadvantage than even the SC, ST population. The High Court noted, for example, that when it comes to the school attendance rates, the out of school being out of school rates of persons with disabilities, children with disabilities, is 4 times even that of the ST, the scheduled tribes population, 4 times out of school rate. And in making these findings, the High Court said in Anmol Bhandari's case, in a very, very broad statement, that disabled persons are at least as much backward, if not more, than SC, ST, and therefore, in every instance, they must be given at least as much relaxation as what is given to the SC, ST. This was a 2012 judgment, Anmol Bhandari, and the citation is 2012 131 DRJ 583. Now that was in 2012. Let's move on forward to 2020 in the Supreme Court. Another college, not in Delhi, in Chandigarh. The Chandigarh College of Fine Arts, run by the Chandigarh government, had made reservation for persons with disabilities, hearing impairment and intellectual disability in their fine arts courses, painting, sculpture, etc. And they did the same thing despite the Delhi High Court judgment. And I must say that it may be a Delhi High Court judgment, but a High Court is a constitutional court, and High Court judgments are to be respected all over the country, not just in the state where the High Court has given the judgment. In any case, the Chandigarh College of Fine Arts again made the same mistake. They made reservation for persons with disabilities in their fine arts courses, but did not give any relaxation in the entrance in the aptitude test. And the result was that Aryan Raj did not get through. Aryan Raj being one of the applicants for the fine arts courses. The High Court unfortunately agreed with the Chandigarh administration, because the High Court in Chandigarh was not aware of the Delhi High Court judgment in Anmol Bhandari. And in legal parlance, this is what is called a judgment being per incurium. When a different High Court arrives at a judgment and not taking into account other judgments which have dealt with the same issue, whether they be Supreme Court or other High Courts, it can be claimed before a superior court that the judgment is per incurium. Per incurium, that the High Court failed to take into account all the other precedent-setting judgments. So the Supreme Court then, in the Aryan Raj case, and this case was decided on 8 July 2020, very recently, said that the Chandigarh College of Fine Arts must give the same relaxation to disabled candidates as to SC/ST, and it said, we follow the principle laid down in the Delhi High Court judgment in Anmol Bhandari versus Delhi Technological University, in which the High Court has correctly held that people suffering from disabilities are also socially backward and are therefore, at the very least, entitled to the same benefits as given to the scheduled caste, scheduled tribes candidates. So this is an important judgment because it makes practically, not only in education, but also in employment, the implementation of all these positive measures, affirmative action, more realistic. Now, the last case in college education, and I must say that this has recently come to a very positive outcome, even though it's a very, very old case. In 2017 December, in a case filed by the Disabled Rights Group, and many of us may know the Disabled Rights Group, which was run by Mr. Javed Abidi, who is unfortunately no longer with us. He was one of those rare people, I think we can say, who really took disability activism through courts very, very seriously. Disabled Rights Group, this was a case where a 16-year-old wheelchair-bound girl applied for admission to the Symbiosis Law College. Symbiosis Law College is a deemed university. And the basic requirements, such as modifications in the hostel bathroom, making a ramp in the college classrooms, etc., allowing an attendant on an as-needed basis were not allowed by a deemed university. And a writ petition as a PIL was filed in the Supreme Court directly. And the Supreme Court directed the UGC to come out with a whole detailed set of guidelines promoting accessibility in higher education. The Supreme Court said a disability is only actually a disability when it prevents someone from doing what they want or need to do. a lawyer can be just as effective in a wheelchair as long as she has access to the courtroom and the legal library, as well as to whatever other places and material or equipment that are necessary for her to do her job well. And in doing so, the Supreme Court, in a detailed judgment in Disabled Rights Group versus Union of India, citation is 2018 2 SCC 397, 15th December 2017. In a detailed judgment, directed that the UGC come out with guidelines covering infrastructure in the colleges, such as the college campus, campus accommodation, classroom infrastructure, laboratories, libraries, etc., but also in pedagogy, that is in the teaching, in the examination and testing modifications, in interaction with the university college administration, and also in the sports, culture, recreation, etc. In all these areas, UGC must come with guidelines. Now, because of the intervening period and the lockdown, the UGC did not do the necessary as required by the court. But interestingly enough, just last month in February, the UGC has just come out with comprehensive accessibility guidelines and standards for higher education institutions and universities. This is a draft guideline dated Feb 2022, which has been published by the UGC for comments. And it is, that I've gone through it, it is a fairly detailed set of guidelines for accessibility in higher education. I would strongly suggest and recommend that all the participants on this in this meeting take a look at this guideline. It is available very easily on the internet. Comprehensive accessibility guidelines and standards for higher education institutions. And please provide your comments to UGC, because this is going to be very important in ultimately what comes out as the final guidelines, which would then have legal force, having regard to the Disabled Rights Group judgment. I'm almost done, Anil. I think you're looking at the clock, right? And we're almost at 2:35.
No, please go ahead. I think you have to still call Vikas Prasad, perhaps would like to read.
I wanted just to, that's the only one remaining. The Vikas Kumar.
I know.
So, the Jija Ghosh judgment, which I read out earlier, talked about rare people, right? Who are the ones who go and find who are the ones who go and make a key to open that locked door. Vikas Kumar was a person who did not have a well understood disability. His disability was focal hand dystonia, which in common parlance is called writer's cramp. It is a neurological condition, a permanent neurological condition, a progressive condition that makes it impossible to move your hand to write at any length. Focal hand dystonia. He had passed medical college with the help of scribes, etc. He wanted to sit for the civil service examination. The UPSC said to him that you do not have the benefit of reservation, because for your category of disability which you claim, there is no reservation. Since you do not have the benefit of reservation, sorry, we can't give you any scribe. It's a very callous answer from a person who has got a documented record of focal hand dystonia, which prevents him from writing. A documented record from NIMHANS, from the Air Force where he was posted at that time. And yet the UPSC response was simply this. In this response, the UPSC ignored a very important provision in our recent 2016 Act, which is the provision of reasonable accommodation. Reasonable accommodation is the mandate in the 2016 Act, which says, quite aside from reservation, the reservation is only given to people with benchmark disabilities. That is, people who have a specified disability of 40% or more. Quite aside from that, there may be people with other kinds of disabilities, which are not benchmark disabilities, not have your own devices. So when there is a requirement for reasonable accommodation, that is providing some facilities, some support system, some adjustments to enable that person to fully participate in the socio-economic life. That is what reasonable accommodation is. This is what the court said. The court set aside the UPSC order and directed that not only in the civil service examination, but in any examination, Vikas Kumar must be given the benefit of a scribe, because his disability is documented. And not only that, the court directed the government to come out with a set of guidelines for provision of scribe to all those who have a documented need for a scribe, even though they may not be eligible for reservation. And the government has in fact come out with a draft set of guidelines. They are yet to be finalized. Now, just the last paragraph of the judgment in Vikash Kumar's case. Vikash Kumar judgment. Is 2021 SCC online SC 84, dated 11th February 2021. This is what the court says. The principle of reasonable accommodation captures the positive obligation of the state and private parties to provide additional support to persons with disabilities to facilitate their full and effective participation in society. The concept of reasonable accommodation is developed further in this judgment. For the present, suffice it to say that for a person with disability, the constitutionally guaranteed fundamental rights to equality, the 6 freedoms, and the right to life under Article 21 will ring hollow if they are not given this additional support that helps make these rights real and meaningful for them. Reasonable accommodation is the instrumentality or an obligation as a society to enable the disabled to enjoy the constitutionally guarantee of equality and non-discrimination. The accommodation which the law mandates is reasonable because it has to be tailored to the requirements of each condition of disability. The expectations which every disabled person has are unique to the nature of the disability and the character of the impediments which are encountered as its consequence. And then the court ends by saying, cases such as the present offer us an opportunity to make a meaningful contribution in the project of creating the RPWD generation in India. A generation of disabled people in India which regards as its birthright access to the full panoply of constitutional entitlements, robust statutory rights geared to meet their unique needs, and conducive societal conditions needed for them to flourish and to truly become co-equal participants in all facets of life. So this was the Vikash Kumar judgment, a fairly recent judgment authored by Justice Chandrachud of the Supreme Court. And this is what I say, we need rare people like Vikash Kumar who facing closed doors and then the door is banged once again on their face. They don't stop. He first went to the CAT. Then he lost in the CAT. He went to the Delhi High Court. He lost there. And ultimately, he finally found his redemption in the Supreme Court. We are not always so lucky. Not all judges are as sensitized as the judge who authored this judgment. But that should not stop us. That should not stop us. We don't win this time, we might win another time. So with that, friends, I close my presentation. I'll be open to any comments, questions, any discussions. I think we have a few minutes left.
Thank you very much, Rajan. Thank you very much indeed for that. Very comprehensive. It's a very difficult area to talk about judgments over such a long period, but you are able to get do the justice to very succinctly by focusing on judgments which are really impact, very focusing. Reminded me of very early days when we used to go together to High Court, and when the railways case, other cases were going on, and Rajan and I used to walk together. And I said it's very rare to find a lawyer who's so committed and so sensitive to disability. Thank you very much, Rajan. I'm sure there will be a lot of questions. So please raise your hands and you'll be unmuted.
Sir, good evening.
Yes, sir. Good evening.
Yeah,
Good evening.
Yeah, sir, I'm asking question through my region language, or interpreter will translate you, sir. It's my comfortable zone. So that
you can ask me in any so long as even English the way you're talking right now is fine. We'll understand what you're saying.
Sir. Actually, நாங்க எய்டட் காலேஜ் டோட்டல் எய்டட் காலேஜஸ் மேல ஒரு கேஸ் போட்டிருக்கோம். ஆக்சுவலா அந்த கேசஸ் பார்த்தோம்னா வந்துட்டு டோட்டலா வருது, லிஸ்டிங் ஆகுது, ஆனா அதுக்கப்புறம் வந்துட்டு பெருசா வந்துட்டு அது மறுபடியும் ஹியரிங் வரமாட்டேங்குது. வந்தாலும் ஒவ்வொரு முறையும் ஜஸ்டிஸே ஒரு மாதிரி வித்தியாசமா கருத்து சொல்ற மாதிரி எங்களுக்கு தோணுது. ஒரு முறை வந்துட்டு ஓகே நெக்ஸ்ட் டைம் வந்துட்டு உங்களுக்கு ஜட்ஜ்மெண்ட் தந்துடுறோன்றாங்க, அடுத்த வாட்டி வர்றப்போ ஒவ்வொருத்தங்க மேலையும் இப்ப நாங்க போட்டுக்கிறது காமனா தான் போட்டிருக்கோம். ஒவ்வொருத்தர் மேலையும் தனித்தனியா நீங்க வந்துட்டு அஃபிடபிட் போடுங்க, நாங்க வந்துட்டு பண்றோம் அப்படிங்கிற மாதிரி வந்துட்டு சொல்றாங்க. ஸோ அதனாலேயே கிட்டத்தட்ட 2 வருஷமா எங்களோட இந்த எய்டட் கேஸ் ரொம்ப முக்கியமான கேஸ், தமிழ்நாட்டுல வந்துட்டு ரொம்ப முக்கியமான கேஸ், ஃபண்டட் பை ஏஐசிபி. ஸோ இந்த கேஸுக்கு பெருசா லாயர் பத்தி நோ கமெண்ட். சோ இதை நாங்க எப்படிதான் அடுத்து கொண்டு போறதுன்னு எங்களுக்கு தெரியல. ஆனா இது ரொம்ப முக்கியமான விஷயம். இது கிடைச்சிச்சுன்னா நிறைய பேருக்கு வந்துட்டு ஜாப் ஆப்பர்ச்சுனிட்டி தமிழ்நாட்டுல கிடைக்கும். அது இமீடியட்டா பண்றதுக்கு எங்க சைட்ல இருந்து என்ன பண்ண முடியும், என்ன பண்ணலாம் அப்படிங்கறத சொன்னீங்கன்னா ப்ளீஸ்.
Okay. So shall I translate?
Yeah, please go ahead.
Yeah. Sir, actually, he's talking about the Tamil Nadu aided actually universities and schools case, sir. Actually, even AICB is not only funded; we are also the co-petitioner of the case. So what he's asking is each and every time. Actually, it's been filed in the year 2019. Actually, so whenever we file a case, he's saying whenever hearing comes, each judge is giving a different views as to the judgment. So and also another thing he is saying is that like whenever it gets listed, sometimes it is coming as a last item. So again, it's not coming for listed. So it gets on it goes on postponing, sir. So what action we need to take to fight this case out?
Rather, we have very senior lawyer for this. Art Prabhakaran, we have a lawyer who's very famous in Tamil Nadu and done a lot of work.
So this is a problem which is unfortunately very common, and it has been exacerbated in this lockdown period, because in the lockdown period even access to the courts was more difficult, and then to begin with, the courts took on fewer cases. The cases you mentioned, this case was a 2019 case, and all the pre-lockdown cases were given kind of the short shrift. Even today, unless you make extra efforts to get the matter listed, pre-lockdown cases are not being taken up. So this is a common problem, and I think a lot of it also relates, unfortunately, to the level of sensitivity of the particular bench to the issues of persons with disabilities. I think that the government, it is high time, the government, through which various judicial academies, have a kind of a training and sensitization workshop for all High Court and Supreme Court judges. Maybe do it in a phased fashion, because I think that very often judges just simply don't understand how critical these issues are. How critical it is that reservation be implemented correctly and properly.
Sir, another thing he's asking, I forgot to mention in the thing. What he's asking is, see, now there are more than 182 colleges, sir. Finally, what the judges ordered to add to make each respondent, to make each college as respondent. So, like, will it not delay the process?
Akka, can you hear? Hello.
Yes.
Sir, colleges 162. Our aided school is 8,300. How can I will with the affidavit each
that's what I asked.
Opposite party.
No, see the thing is that the schools are under the directions of the Department of Education of the state. So the schools need to follow the instructions of the Department of Education of that given state, in your case Tamil Nadu. So there is no need, and it is impractical to make 4,000 odd schools all individual parties. If reservation is not being implemented at the school level or at the college level, the relevant departments of government, that is the school education and the college and the higher education departments, in the first instance should be adequate to issue the necessary instructions.
Yes.
And the other remedy is this, that once a court endorses or sends or passes certain directions that reservation in higher education or in school education must be implemented, and directs the relevant department of the government to do the needful. Any particular school or college which is not doing it despite the court's order can be proceeded individually in contempt.
But again, the difficulty here is the court itself is delaying. They want us to make the others respondents.
Yes, sir.
That is the problem.
That's right. So my contention would be that it should be argued before the court that it is impractical to make 4,000 odd schools respondents. whereas the adequate respondent is in fact the government department, which is the authority responsible for issuing necessary instructions. The higher education department as well as the school education department.
School education.
Yes,
Tamil Nadu.
absolutely.
சார் இப்போ சுப்ரீம் கோர்ட்ல செட்டில்டு பண்ண ஒரு விஷயத்தை இவங்க திரும்ப இப்படி பண்றப்போ அது வந்துட்டு கோர்ட்டு அவமதிப்பு கண்டெம்ட் ஆஃப் தி கோர்ட்டுக்கு நம்ம போக கூடாதா? அதே ஏதாவது ஒரு மாதிரி நம்ம கொண்டு போக முடியாதா?
Sir, he is asking when the matter is settled by the Supreme Court, because recently we have this case, won by this Kerala Federation of the Blind, whereas it was held that all aided, including minority institutions, also should give reservation. So he is asking when a matter is settled by the Supreme Court, can it be not taken as a contempt of court?
See, practically speaking, now one can, in theory, when the Supreme Court has passed a judgment that reservation in promotion should be granted, reservation in education should be granted. If there is a direction to that effect, covering all the colleges and schools, then one can, in theory, file a contempt petition directly in the Supreme Court. But because of the impracticality of that all over the country, people would then go up directly to the Supreme Court for implementation of a judgment that it has passed. It will not be practically possible for the court to really entertain those kinds of things. So it is more practical to go to the High Court, as apparently you've done in this case.
Okay, thank you so much, sir.
Yeah. Any other?
Next.
யாரா இருக்காங்களா? இல்ல நான் இன்னொரு
Shivakumar
question
sir.
Moganandam
Raja wants to ask another question, so can we?
Okay.
Yeah, please go ahead.
Yeah, Raja. Go ahead.
Yes, Raja, please go ahead.
He's unmuting.
Can you hear?
Yes.
அதாவது என்னன்னா இப்ப எஸ்டி ஹிந்து காலேஜ் அந்த கேஸ் வந்துட்டு நாங்க கமிஷனர் கோர்ட்டுக்கு கொண்டு போயிருந்தோம். கமிஷனர் கோர்ட்டுக்கு சரி நம்மளால செலவு பண்ண முடியாது அப்படின்னு கமிஷனர் கோர்ட்டுக்கு கொண்டு போனா
Raja, you're muted. Raja, you're muted.
Raja, we are unable to hear you.
I think the person asking the question is on mute, right?
Yes.
Yeah, I got his question.
What is the question? You translate? Yeah.
Can I go ahead with this question?
Yeah, please go ahead.
So, Raja, you're muted. Actually, we can't hear you. No, he
Go ahead,
was
whatever you. Yes,
okay.
yes.
So actually, through CSGAB, they have filed a case in the state commissioner, sir. Actually, state commissioner against one aided college, that is ST Hindu College. So because they said for every case they are not able to spend, so they brought this case to the state commissioner. But state commissioner is saying they cannot even give recommendation, they cannot give advice or something. And then in the middle, after two hearings, they said the case has been filed in Madurai High Court, so we cannot do anything. So as such, they have kept this without doing anything. I think he is asking to.
One of the difficulties with this our latest 2016 Act is that unlike the 1995 Act, which gave the power to the commissioner to issue directions in cases of complaints coming to their notice, the latest Act gives the power to the commissioners to issue recommendations, which are not binding. But on the other hand, the Act also says that the recommendation shall be complied with within 3 months, unless the department gives cogent reasons for not doing so. It's a double-edged sword, because on the one hand, not having the power to issue binding directions, but having the power only to issue recommendations may appear like it is diluting the powers of the disability commissioners. But I would argue that on the other hand, it gives the disability commissioners a lot more leeway and width to pass strong recommendations Because those are recommendations, and they do not need to worry about, for example, invoking the ire of their superiors, etc., because they ultimately report to the same department administratively. They can issue recommendations of great strength, which will help a lot when the matter goes further to the High Court. Because whether it is a recommendation or whether it is a direction, it is still an adjudication by a statutory authority. So the power of the commissioner, even if it's a recommendation, is still an adjudication. It still has that force of an adjudication of a judicial finding, which will be treated with respect and consideration in the higher courts. So therefore, I would say that don't be discouraged if commissioners are saying we can only give recommendations. Tell them, please give a recommendation and give a strong one.
Yeah, we told that also, but they are not ready to even give any recommendations. They are not ready to do anything.
The second aspect that you mentioned.
ஒவ்வொரு முறையும் என்ன பண்றாங்கன்னா, ஓகே இவங்க கொடுத்துட்டாங்க, நீங்க பதில் சொல்லுங்க. ஓகே இவங்க கொடுத்துட்டாங்க, நீங்க ரெண்டு பேர்கிட்டயும் மாத்தி டாக்குமெண்ட்ஸ் கேட்கறதுல மட்டும்தான் அவங்க இருக்காங்களே தவிர அதை தாண்டி ஒரு வேர்டு கூட கேட்க மாட்டேங்கிறாங்க. ஈவன் கமிஷனர் இருக்கிறவங்க எல்லா கமிஷனுமே கேள்வி கேட்கும்ல, அந்த மாதிரி கூட இவங்க கேட்கலங்கிறதா எனக்கு ரொம்ப பெரிய வருத்தமே.
He is saying he is worried about the fact that they are asking petitioner's view and the respondent's view, and they are not taking any. He is not giving his views, or he is not ready to pass any order, and he is not speaking one word for or against the case. That is what he is saying. So mostly in Tamil Nadu, apart from welfare measures, they don't want to exercise the quasi-judicial powers, state commissioners. That's the problem.
Now, the other thing which you mentioned is that the same matter, the same case is being pursued before a high court as well, right? I think you mentioned that.
By a different petitioner. By a different petitioner.
By a different petitioner. Okay, it's not the same petitioner.
No.
So if it's a different petitioner, then that is no reason for the commissioner not to pursue with this case. So, if he is unwilling to take this case forward, I would recommend filing an application. You already filed a complaint, right?
Yes.
File an application, a short application requesting for fixing a date of final hearing in the matter, because this is a statutory authority, and they are obliged to hear the matter and decide the matter. It's an adjudication. It may be a recommendation ultimately, but it's an adjudication. So filing an application, a short application, giving the quick background about when the hearings took place, etc., when the complaint was filed, when the counter affidavits were filed, etc., and then asking in the application a prayer, please fix a date for final hearing and adjudication of this matter. Because if that is not adhered to, if a date is not fixed, the matter is not finally heard, that can be a ground for going to the High Court against the commissioner himself or herself.
Yeah, thank you. Actually, Rajan, the way I read this 3 months rider is on the negative. Because earlier, since there was no time bound, out of decency or some ignorance, should I say, the respondents would comply, thinking it's a court order. Now there's a provision to give a reason. And I have also been an administrator along with an activist, so I know giving reasons is not very difficult. We can just say due to administrative and financial constraints we are unable to do that, and let the person go to High Court and fight it out. So then you see it becomes a second innings for the petitioner to go to High Court, where we will defend through our lawyers. You are right that recommendations are very important. We are fighting a case in High Court where we got a favorable order in the CCPD. The respondents have gone to High Court in that case, and we are contesting. But you see, it still becomes a very long wait for the petitioner. First, we spend time in CCPD, whatever order we get, but then we go to High Court and spend equal amount of time and more. Perhaps it is much easier than to go to High Court and argue straight away. So I think the powers of the Chief Commissioner are weakened in the present act. I strongly argue, and particularly when we have the the Secretary of the Government as the Chief Commissioner, what adjudication can you really expect?
Yes.
I mean, how can the Secretary speak against the government itself?
Yeah. But on the other hand, we've also seen some very, very good decisions come from the commissioners, right?
Yeah. When they have been,
the Chief Commissioner alone, we are getting decisions, sir, but not from State Commissioners.
State Commissioner pretty bad, yes. And you, Chief
This is
Commissioner,
why, yes.
Actually, I remember
when-
one case argued by Anil Aneja, sir, recently against one person in Tamil Nadu, sir, for one person in Tamil Nadu against Repco Bank, actually. First, he has sent a letter, and he has filed this case to State Commissioner only. I have read the State Commissioner's letter to the Repco Bank. They have just quoted only Section 20, sir. Other than that, no Section 33, 34, nothing was available in the,
Right.
it was in the letter format. Then we filed a case in CCPD, AICB for him. Then Aneja sir argued and immediately they passed an order. Now he was recruited. So decisions, good decisions were given by Chief
and we were
Commissioner
able to get that implemented. Both Repco
Immediately.
Bank case and Anoop's case, both in Tamil Nadu,
yes.
Aragya Parivat, 3 cases.
And the
we were able
Indian
to get the
Bank
case
also,
orders
yeah.
implemented. But that's the thing now, it's very subjective. People sometimes do it, sometimes they don't do it, So
In
I
fact,
suppose it must depend on
against
the lawyer of the bank. If the bank lawyer says no, there's no scope for appeal, they would implement. If there is scope for appeal, they will not implement. That way. So yes,
I would agree that at the State Commissioner level, there seems to be not only a lack of sensitization, adequate sensitization to what the law is and what the real problems are, and of the power of their office. They should be aware of that. To me, I think one of the things that we as a sector ought to be thinking of doing is really having the government organize some kind of workshops. Because these days it's much easier with Zoom,
Actually,
etc.
they just don't want to summon the government, so that is their problem. Mental this thing, sir.
It's position now. They want to chair.
They don't want to summon the
and
government.
Invariably, these are additional charges. They are staff of the government, employee of the government.
Absolutely,
So
absolutely.
because ultimately they have to go back to the
I would agree with that, and I think that the time is right now where there should be some very, very strict observations coming from a higher court.
Correct, sir. Yes.
About the requirement of proper because these are not just casual proceedings; these are statutory proceedings mandated by law and mandated by international law as well. It's the only grievance redressal mechanism available to persons with disabilities in the first instance. So it is high time, in fact, that we, in fact, I would say that we can begin by noting really where the most egregious cases are in the country. And maybe taking up some advocacy type efforts to bring attention not only of the state government, but also of the central government to the functioning of these commissioners. Also keep in mind that the other statutory bodies that have now been activated, although they're not very active, although they're activated, are the disability advisory boards. There are now disability advisory boards in all states.
Yes.
And also at the central level. So letters to the advisory boards, quite aside from the government departments, highlighting cases where, and the letters have to be properly drafted, have to use judicious language, but the functioning of these commissioners in the most egregious cases should be brought attention.
I think there's a good case for very strong advocacy in this.
Yes,
maybe Rajan, you and I can work together. We get the RTIs and get the information from State Commissioner, how many cases been adjudicated, what is the compliance level on them, and how many of them are additional charges, what is the normal duration of cases.
Yes.
After all the data we get, we go to Supreme Court, asking for the fact that these are all statutory posts, therefore additional charge. But we have a situation, even in the center, we don't have a Chief Commissioner for many years. So
yes,
that is unfortunate. Yes.
So next we have Shivakumar.
I am Dr. Shivakumar from State of Tamil Nadu. Many Central Act and State Acts provisions have not implemented in the state of Tamil Nadu, like Food Security Act, Andodya scheme as allocated for persons with disabilities. Yet today, the state government has not implemented. There is no provision. Are you differently abled, or are you persons with disabilities? The question itself not available in its website or in the application. There are many acts are not implemented fully effect for the persons with disabilities in the state of Tamil Nadu.
Yes. Yes. So I think what the question is that for all the various welfare schemes or positive measures that are available to the society at large, or to the more needy elements of society at large, like for example PDS or like MNREGA. I think what the questioner is saying, what you were saying, is that there is no particular special provision for persons with disabilities in those arrangements. Is that right?
Yes, sir. Many like one example act. There are many acts provisions for the persons with disabilities is not implemented in the state of Tamil Nadu. We have filed many representations. There is no reply on it.
Shivakumar sir is an RTI activist. He has filed more than 1,000 RTIs against universities, colleges, and disability department.
That is excellent, Mr. Shivakumar. We wish you a very long life for being in. This is very important. It's very, very important to take up causes like you have. I think what needs to be done in situations like this, and what has been done in a more recent circumstance, you will recall that during the COVID-19 pandemic, there were a lot of government instructions at the central and state level, and a lot of arrangements were made. I'm sure, Anil, you're very aware of this, for vaccinating people all over the country against COVID. But the particular problems of persons with disabilities were not in the first instance even recognized. So if you're a person with visual impairment, how do you make it all the way to a vaccination center? How do you go through the entire process? If you're a person with mobility issues, you need somebody to come to your house perhaps to do it. There was absolutely no recognition at all. And it was only people from the sector who brought this up to the government. And then ultimately the central government did issue instructions to all the states to have separate vaccination centers with all the necessary facilities for people with disabilities. And to a certain extent that was implemented during the COVID-19 pandemic. So I think it really boils down to when you're saying that there are certain schemes and certain beneficial laws that implement welfare schemes for all manner of needy people, where persons with disabilities are not being recognized separately, then we need to identify exactly where the issue is, what the problem is. For example, if MNREGA, what are the precise issues where MNREGA is not as accessible to people with disabilities as to other needy people? Or PDS.
So we have done a study, Rajan, on this in 2011. AICB did a very comprehensive study on MNREGA and NHMB schemes, and we found that
sir
only
was the investigator.
Yes, I was the coordinator for that, the principal investigator, and we found that not more than 2 or 3% visually impaired person out of 100 MNREGA beneficiaries, PWD ratio was very, very limited, and out of that, the visually impaired was the least.
Yes.
So there were many issues. We've done the study. We sent some recommendations to the government, and there was a revised instruction issued in 2012, in which 90% of our recommendations were accepted.
Yes.
So we did that work. That Raja is there.
I would like to request one thing, sir. AICB can forward to identified what are the schemes and act provisions have not implemented in the state of Tamil Nadu. Project will start and find out many things. We will take out to the legal remedies, sir.
Yeah, please make a project.
Sure.
And we'll try to provide support, but the initiative has to come from the affiliates.
Yeah.
Not from
Just to
AICB. You have to
Mr.
give
Shivakumar,
Yes,
my comment to you is that, see, when we are trying to resolve issues through the legal channel, through the implementation of law in general, not only do we identify what the issue is, but we also specify what the solution should be.
In Right to Education Act, there are many provisions for the persons with disabilities. It is not fully implemented in the state of Tamil Nadu.
Yeah, so you make a case, send it to us.
Yes.
Send us the issue, send us the problem, what support you require. We'll be very happy. In Tamil Nadu, we have done a lot of work, Mr. Kumar. We've done a lot of work. We'll find many cases, and we'll be happy to do more, provided we hear from our affiliates or interested activists. Mr. Sir is always there. You be in touch with her and tell us what you require once she processes that, we will be very happy to do the needful to a possible
The
extent.
general comment I would
Thank you,
make
sir.
is that when we are seeing that there are problems of non-inclusion of people with disabilities, we have to be very precise about what the real problem is, where the non-inclusion is, and what precise recommendations and solutions we are suggesting. Because when you are very clear as to what you want, then the grounds for giving that follow. But if you only state the problem in a general way and don't state exactly what it is you're looking for, then the problem gets stuck where it is. So I would say that, as I said, for example, in the case of the vaccination schemes for COVID-19, a very precise requirement that, let's say, for people who are locomotor disabled, they should be coming to their homes to do the vaccination, or whether they have certain other provisions for people at the vaccination center for those who, for example, are visually impaired and so on. So there has to be a very strong focus on what it is that you want out of the entire process. And then you work back towards what are the grounds for demanding it.
Thank you, Rajan, which I'm sure you could go on discussing. There's so much and you have so much resource. But yes, there are other next session and you are very busy. So we wouldn't like to make more demands on you because you're very kind. But I'm sure, we don't want to hold you from the other work. Thank you very much. It's been wonderful having you over. A very interesting afternoon. Thanks a lot.
It was a pleasure and a privilege to come.
I look forward to working together with you as always on various important issues. Thank you.
Absolutely.